The state alleges that you committed the offense of criminal vehicular homicide.
To drive, and I still have medicine that's at my pharmacy, and I gotta get back to my son.
Can you confirm that the Ransom County Courthouse's courtroom is open and the building is open and it's open in public there as well?
It is, Your Honor.
All right. And we are also live streaming this event on the Southeast Judicial District's live stream YouTube channel. Any member of the public or media can attend these proceedings either in person in Stutsman County, in person in Ransom County, or alternatively by following along on the live stream YouTube channel. This case is set for an initial appearance. The court notes that it signed an order for expanded media coverage, which was requested by several news media agencies. There is a proposed application for indigent defense services. The court notes that under Section A, there are positive responses to receiving TANF and supplemental Social Security income. As such, automatically, the defendant qualifies as indigent for public defense services. The court is going to appoint a public defender. The Indigent Defense Commission will provide you with an attorney. I'm simply going to let them know that I find that you qualify, ma'am. And then the Public Defense Commission will send you notice of who your attorney is. You need to stay in touch with that attorney. But for today's purposes, your attorney isn't present because I just acted here seconds ago. Are you okay with proceeding today for purposes of setting your bail without an attorney, ma'am?
Yes, sir. Can I say a few things?
We'll get there, and I'm going to advise you against it, but we'll get there. So, ma'am, were you present in court when your rights were read to you?
Yes, sir.
Do you understand your rights?
Yes, sir.
One of those important rights is the right to counsel. And again, you have the right to hire a lawyer of your choosing. You have the right to apply for a public defender, and you have the right to represent yourself. You have applied for a public defender, and the court has appointed a public defender for you, but that public defender is not available right now. You have agreed or consented to moving forward so I can set your bail today. Understand, ma'am, that you will have the assistance of counsel as soon as possible through the public defense system, and that no matter what I do with your bail, you have the right to have your bail reviewed within 48 hours if you remain in custody. And you are not waiving your right to counsel for any other purpose other than today by consenting to agree to move forward today. Do you understand that?
Yes, sir.
Have you received a copy of the amended charging document in this case?
Yes.
I can't see. I can see.
Sorry, I was asking someone.
I can see that you're holding up a sheet of paper, but I can't read the sheet of paper. The camera isn't that good, and neither are my eyes. So.
The state of North Dakota versus Amber Patel.
Correct. And in the upper right-hand corner, it will have a case number, and it will say amended criminal information. Is that the document you have?
Yes, sir.
And is your name spelled correctly on that document?
Yes, sir.
Okay with the court summarizing the document for you?
Yes, sir.
The state alleges that you committed 2 offenses in the county of Ransom County on or about August 6, 2024. The first count, the state alleges that you committed the offense of criminal vehicular homicide, in that you were under the influence of alcohol or an actual physical control of a motor vehicle, and that you were involved in an accident that involved or caused the death of another individual. As charged, ma'am, that is a Class A misdemeanor. I'm sorry, Class A felony. It is not a misdemeanor. Class A felony. Class A felonies are punishable by a maximum penalty of a fine of up to $20,000, imprisonment of 20 years, or both. There are applicable minimum mandatory penalties. If you do not have a prior driving under the influence or reckless driving conviction on your record, the minimum mandatory penalty is 3 years imprisonment. If your conduct caused the loss or financial harm to another person, the court can order you to repay that person and to make that person whole. We call that restitution. If you are not a United States citizen, that offense carries with it a potential for adverse immigration consequences. Associated court fees for a Class A felony are $1,060. Moving on to count 2 as alleged. The state also alleges that on or about that same date, you engaged in driving under the influence, or that you were in actual physical control of a motor vehicle while under the influence, as charged that is a Class B misdemeanor. The state alleges that you were under the influence of any drug or substance on a public roadway in Ransom County. Mr. Kelly, are you also alleging alcohol or intoxicating liquor?
No, Your Honor.
All right. And so a Class B misdemeanor carries with it a maximum penalty of 30 days in jail, a fine of up to $1,500 or both. It also carries with it minimum mandatory penalties that were not alleged on the amended criminal information, and they need to be alleged on the second amended criminal information the court is going to order Mr. Kelly to file in a bit. Minimum mandatory penalties for driving under the influence include a $500 fine and an addiction evaluation by a licensed addiction counselor. Associated court costs with that offense, $285. Again, if your conduct caused any loss or harm to another person, financially, the court can order restitution. If you're not a United States citizen, that offense can have with it adverse immigration consequences. Do you understand the nature of the charges, the maximum penalties, the minimum mandatory penalties as I've read them, the court fees, the potential for restitution, and the potential for adverse immigration consequences?
Yes, sir, I understand.
Because your case involves a felony, the court is not going to take any plea. Instead, what the court is going to do is set another hearing. That next hearing will be called a preliminary hearing. A preliminary hearing is a threshold probable cause hearing to determine whether or not probable cause exists that a crime was committed, and probable cause exists that you committed it. If the court finds probable cause, either after a hearing where you have a contested hearing or you waive your right to a preliminary hearing, then we would get to the arraignment. And the arraignment is much like today, but at that time, the court will take a plea of guilty or not guilty. The court is not going to do that now. All that I'm going to do today is I'm going to set your bail, and then we'll wait until that next hearing happens. Do you understand that?
Yes, sir.
All
Your
right.
Honor.
So I'll hear first from Mr. Kelly on bail, and then I'll hear from you. And then I'll give Mr. Kelly the last word because he's state's representative and they bear the burden with respect to bail. So go ahead, Mr. Kelly.
Thank you, Your Honor. Your Honor, the state is looking at Rules of Criminal Procedure, Rule 46, Subpart 3 on release condition factors. Factor A is the nature and circumstances of the offense charge. In this case, a person died as a result of the allegations. This is alleged as an A felony, the second most severe criminal charge in North Dakota. Factor B, the weight of the evidence against the person. In this case, the affidavit of probable cause shows that the defendant admitted to having ingested at least 9 different drugs on the day in question, many of which were prescription, and six of which had a warning label that stated may make you drowsy or dizzy and use care when operating a vehicle. The defendant made several admissions against her own interest, including admissions that she had taken more than the prescription as far as the amount of those prescribed drugs on the day in question within certain prescribed time periods. She showed evidence of being under the influence, and she made statements against her interest about feeling under the influence. And she stated, among other things, one of the things she said is that a urine analysis would return amphetamines and her prescriptions. When looking at factor C, the person's family ties, employment, financial resources, character, and mental condition, many of those are unknown to the state at this time. It is believed that the defendant has relatives in Georgia and or other states in the South, but that she has, under factor D, the length of the person's residence in the community. She has allegedly lived in this area for 10 or more years. Factor E, the person's record of convictions. The state would like to point out that it appears that the defendant was charged back in 2005 with a DUI. It's not sure what the resolution or the disposition was on that case, but it does show a misdemeanor conviction for disorderly conduct. It also, the criminal history does show that in more recent years, starting in 2020, the defendant has a pattern of behavior that it appears led up to these unfortunate and tragic events involving the death in this case. 2020, there's a case showing driving under revocation or suspension. She has a 2022 speeding 10 miles an hour over. She has a 2022 failure to wear a seatbelt, 2022 failure to maintain control, distracted driving, 2022 speeding 20 miles per hour over, 2022 failure to wear a seatbelt, another failure to wear a seatbelt, 2022 a 15 miles per hour over the speed limit, 2023 a 10 miles per hour over the speed limit, 2023 failure to wear a seatbelt, 2024 10 miles per hour over, and another 2024 failure to wear a seatbelt. The state alleges that those criminal history facts show that this defendant should have a higher bond for factor G, which is the nature and seriousness of the danger to any person or the community posed by the person's release. In this case, a 24/7 ankle bracelet would not be sufficient because that only monitors alcohol use. There's no allegation of alcohol use here, but prescription drugs. A drug patch would probably only show her prescription use of drugs, but it wouldn't show if she's overusing drugs. Because of the pattern of behavior and because of the admissions that the defendant made in the investigation in this case, that she was overusing her prescription drugs, which it allegedly and apparently led to impaired operating of a motor vehicle, the state believes that there's a high risk to the community. And for all of those reasons, Your Honor, the state asked for $50,000 cash or $100,000 surety in this case. Thank you.
Mr. Kelly, did you say there was a potential for a DUI in the previous history?
Yes, Your Honor. It's not clear what the final disposition on that one was. It's out of Georgia, Your Honor. It looks like she was charged with that, and it's not clear whether she was adjudicated on the DUI or if the charges were amended to disorderly conduct.
All right. Well, I think you need to figure that out, Mr. Kelly, because it changes the minimum mandatory penalty substantially.
Yes, Your Honor.
And so, Ms. Patel, I want to explain something to you before I get your position and thoughts on bail. So as alleged, the state has not alleged that DUI prior. The statute that applies, Century Code Section 390801.2, subsection 1, says that if you have a prior DUI or reckless driving conviction, it does not say within the past 7 years or the past 15 years like the typical DUI statute. It says if you have a prior conviction, the minimum mandatory penalty is no longer 3 years, it becomes 10 years in prison. And so you are subject at least as alleged right now in the amended criminal information, to a 3-year minimum mandatory penalty with a maximum penalty of 20 years. If you have a prior conviction, and you may or may not, but if you have a prior conviction, that minimum mandatory penalty is 10 years, with the maximum penalty remaining the same at 20 years. Do you understand the basis for that advisement, ma'am?
I do.
All right. And so you've heard what the state has alleged and requested in terms of bail. What are your thoughts on what I should do about your bail?
I beg you, Your Honor, to put me on house arrest. I have a son at home and he has nobody but me. He starts school next week. I'm scheduled to have back surgery. I see my back surgeon August 29th. I've got a lot going on and I just beg for house arrest because my kid needs me. He has nobody else but me.
Anything else, ma'am?
And I won't be driving. I'm too scared to drive. And I still have medicine that's at my pharmacy, and I gotta get back to my son, and I don't have no money or assets.
Ms. Patel, where do you live?
I live in Oaks, North Dakota.
How long have you lived in Oaks?
I lived in Oaks for 12 years. 12 or 13.
And who else lives with you in Oaks?
It's just my son and I, and then my mother lives down the road.
So your mother lives in town?
Yes, sir.
Your son's in town?
Yes,
You're
sir,
in
but
town?
she's not able to take care of him with her work schedule.
Stick with me. Just answer the questions that I'm asking, please. Are you working?
No, sir, I'm on disability.
Okay, when was the last time you worked?
I don't remember.
All right, and your disability is related to a back injury?
Bipolar and a bad back.
Okay. And your son starts school in Oaks?
Yes, sir, next week. All he's been doing is crying.
Where is your son's father?
He's incarcerated in Georgia.
Do you have any other ties to the community?
No, sir.
All right.
I beg for house arrest.
When was the last time you were back in Georgia?
I visited Georgia this year. I think it was May 30th to June 7th. I flew down there with my mom and everybody to see the family, and I came back. I promise you I'm not a flat risk. As soon as I found out I had a warrant for my arrest, I turned myself into the sheriff. I'm not trying to run. I just want my kid.
Mr. Kelly?
Yes, Your Honor.
This charge was amended from criminal vehicular injury to criminal vehicular homicide after the victim passed away, correct?
Yes, Your Honor. It was filed after the victim passed away. Yes, Your Honor.
But initially, it was charged as a criminal vehicular injury before he passed, right?
That is correct, Your Honor.
And bail was set at what?
There was not a bond hearing, Your Honor.
And so she was released on a promise to appear. Is that your understanding?
I think the officer issued a traffic citation, which the state did not have anything to do with. The state would have opposed that, Your Honor.
You didn't request a hearing immediately to set bail, did you? Or long form her at the time?
I long formed as soon as I could, Your Honor. I believe it was on the day that I long formed was August 8th. And that's when I had information. I was waiting for affidavit of probable cause information. And there was no bond hearing requested because the defendant was not in custody.
All right. And is it true? Did she self-surrender on the warrant?
I'm not aware of that. I have no reason to refute what she is claiming, Your Honor.
All right.
The state's main concern, Your Honor, is the nature and seriousness of the charges and the danger to the community based on the allegations in this case, Your Honor, and based on that pattern of behavior.
Mr. Kelly?
Yes, Your
So
Honor.
the North Dakota State Constitution, Article 1, Section 11 or 12, I don't recall right offhand, says that all defendants are bailable upon sufficient sureties. And then we look at Rule 46A, and in Rule 46A, there's a presumption of release on one's own recognizance or unsecured appearance bond unless the court believes that presumption has been overborne concerning whether or not the defendant will appear. And if so, then the court can consider the factors you outlined. Is that your understanding of the rule?
It is, Your Honor, and the state's position is that the presumption can be rebutted and overcome in this case because of the pattern of behavior of the defendant in the past, which shows that there is a probability that the defendant will not appear because she'll be involved in other dangerous criminal acts.
Has there been any failures to appear on anything in her history that you're aware of?
Not that I'm aware of, Your Honor.
All right. Ms. Patel, anything else that you want to tell me before I set your bail?
Your Honor, I just have no money or assets. My mom don't have no money or assets. I just want to get back to my kid. Please put me on house arrest. I don't plan on running or anything. I just want to be with my kid. And I promise you I'll be at the next court appearance. I will be there. I turned myself in. That's why I'm here now. Please.
All right. So the court has considered the constitutional requirements of bail and Rule 46 in its entirety, including the presumption of release on one's own recognizance or unsecured appearance bond in Rule 46A concerning whether or not the defendant will appear in court. Here, at a minimum, when this case was initially charged and serious injuries were alleged, as set forth in the Declaration of Probable Cause, the defendant was released on a promise to appear. After the passing of the victim, which is horrible and tragic, and the court is aware of the impact and the ultimate result, but I'm careful to not conflate whether or not Ms. Patel will appear in court with the strength of the evidence against Ms. Patel. Right now, she is presumed innocent until she's proven guilty. The presumption is that I'm supposed to release her on her own recognizance or unsecured appearance bond unless the court believes she's not going to appear. Here, after she knew what happened, and after the officer knew what happened, she was cited and released by the officer because there was no concern that she would not appear. The state is now asking for a substantial amount of money for bail. Under Bandy versus United States, when it comes to indigent defendants, even a modicum of bail might result in unconstitutional preventative detention. And again, under Stack v. Boyle, again, another U.S. Supreme Court case, the Supreme Court has stated that preventative detention is not authorized by the statute. The purpose of bail is to ensure the defendant appears in court. The court can consider risk to the community and dangerousness if the court first finds that there's a flight risk. Here, there are some ties to the state of Georgia. There are, however, significant community ties in the county of, or in the city of Oaks. In particular, the defendant is a single mother who has a child in the Oaks school system, has a mother that lives in Oaks, has lived in Oaks for 12 years, has significant ties to the community in that respect. When weighing all the factors here, again, regardless of what I set as my bail figure, I express no opinion on the strength of the evidence of the case. And I certainly acknowledge that the result here is a horrible one, but I can't conflate what might be proven at trial or what might be reported in the media or might be asserted in an affidavit of probable cause with the presumption of innocence. And so here the court is going to set bail. I find that there are concerns concerning the defendant's willingness to appear in court because of the ties to Georgia.
Okay, y'all tell him to turn
Stop
us
talking right now. So the court does have sufficient concern to consider the factors that are laid out later in Rule 46 to overcome the presumption of release on one's own recognizance. But the court takes those into consideration as a whole. And as a whole, so long as we can ensure the defendant is not driving or operating a motor vehicle, the court finds that the defendant is likely to appear in court. And so I'm going to set bail. It is going to involve some financial conditions. It's not going to be zero. It won't be an unsecured appearance bond, nor will it be a cash only bond. But it's not going to be what the state is asking for either. So bail will be set as follows. I'm going to require $2,500 in cash. On the alternative, $5,000 corporate surety bond. Additional conditions of release. The defendant shall not violate the laws of any city, county, state, or nation. The court determines that you shall not leave the state of North Dakota without the advanced express permission of the court. You shall maintain appropriate contact with your defense lawyer because the court has appointed a public defender. That contact must be weekly. Your attorney is obligated to report a lack of contact to the court. You must notify the court within 24 hours of any change of address, employment, phone number, or email. You are subject to house arrest. You shall be confined to your place of residence except for court appearances, medical appointments, work, and meetings with your attorney. You shall not possess or consume any alcoholic beverages or controlled substances except as authorized by a licensed physician and only in the amounts and as directed by a physician. So to be clear, if your medication says take 1 pill 3 times a day, that means you take 1 pill 3 times a day, not 2 pills in the morning and then 1 pill at noon and 6 pills at night. It's as prescribed. Do you understand?
Yes, sir.
You'll undergo any reasonable medical or other examination or testing to determine your compliance with the requirement. You shall sign a promise to appear in waiver of extradition before release. You shall not possess a firearm, destructive device, or other dangerous weapon. You shall personally appear for all scheduled court appearances and hearings unless excused by the court or by the filing of a proper waiver of appearance filed by your attorney. Your next court date, ma'am, is a preliminary hearing scheduled for September 4, 2024 at 1 p.m. in the Ransom County Courthouse in Lisbon, North Dakota. Do you know when you need to be in court next?
Yes, sir. September 4th in Lisbon, North Dakota. What happened?
Lastly, no driving whatsoever. So no operating a motor vehicle for any reason while you're on pretrial release. Before release, you must submit to fingerprinting and DNA sample submission before you're allowed to go, even after posting bail. If you remain in custody for longer than 48 hours following today's hearing, you can request a bail review, and any magistrate in the district can review the bail. Bail might go up, it might go down, it might stay the same, but you do have that right to a bail review. So ma'am, I've cut you a substantial break from what the state is asking for. I have not done what you asked, which was simply to put you on house arrest without any modicum of bail. The court has taken into account your disability and ability to work, the likelihood of flight, the likelihood of dangerousness to another person. The court finds that that dangerousness was tied to driving. If you have no vehicle to drive and you are not driving, the dangerousness substantially reduces. Again, it says nothing, and the court takes no opinion about the evidence in the case, the strength of the evidence of the case. The court knows and is aware of the result of the alleged criminal conduct. But ultimately, that's for a jury to decide or the parties to negotiate. I'm not going to get involved in it. I simply believe that you're going to appear in court, because if you don't appear in court, I would expect Mr. Kelly to file a bail jumping charge, which would compound and criminalize not appearing in court. Do you understand that?
Sir, I'll be in court.
If you're not, there will be consequences. So as long as you understand that now, that's what the court needs you to understand, that you need to be back in court as directed.
Yes, sir.
Mr. Kelly, anything else?
No, Your Honor.